And I will call the special meeting of the Groton Board of Education to order at 7 p.m. And the first item will be the review of the fiscal 2024 budget challenges. So do you want to lead us in that, Susan?
I will. I'm going to actually turn it over to Dave Fleig. We've actually reviewed this and sent out some documents for the board to look at, and I'm going to let him kind of direct us. Do you want to put up the document, or do you want to say anything to it first, Dave? The first attachment that you'll be showing them, orient them.
No, I thought I'd just open with just sort of a general overview of the approach, at least.
Okay,
I shared some of this with the Finance Committee probably a week or so ago. It's been fluid, and for my partners on the Finance Committee, as I go through, I'll tell you some things that have changed. But I thought tonight, at least, we don't have much time, but I'm going to get you into some of the details as I sort of forensically start to go through our P&L and understand where we have some challenges. And then you'll see on the right-hand side just early observations of some opportunities for us in terms of levers that we might be able to pull. So if we can, I don't know, am I driving here? You want me to pull up the sheet, or?
Can you pull up the sheet?
Yep.
I can find it if you can.
Can everyone see it?
Yes.
Perfect. Okay. So long sheet, but if you can follow along just for 1 second, I'll sort of explain my process. So I started over on the left-hand column with our full year 24 budget. We're probably all familiar with that. Ties out to the budget book. And then I just tried to classify and categorize sets of expenses where we're early part of the year, we were having some challenges. The first box, I think you've heard me talk about a few times at least. So if you refer to Exhibit 1, I'm not going to pull up each exhibit. I'm going to kind of stay on this one. But if you refer to Exhibit 1, these are expenses from fiscal year 23. So incurred last year that we're paying out of the budget this year. So for my finance friends on the Finance Committee, this number is a little larger than what you've seen. And just to give you an example, I just received 2 invoices last week from 2023, and it was January 28th.
Wow.
So this is becoming more and more fluid. They were fairly significant. It was about, I'm going to say $45,000 in total. But I'm trying to keep track of these because theoretically we should have paid those last year. Okay, so the next bucket are property costs, which we've been talking about for a little while now, but thought I'd kind of just keep it out in front of you. So this is Exhibit 2. I'm not sure much has changed since the last time you've seen this. I think what's becoming a little clearer is some of the estimates around the hot water heater over at Fitch. I think Sam is getting some tighter numbers on that, so we'll true that up. But essentially on a gross basis, we're looking at about $240,000 of unexpected expenses just related to this bucket. So I'm going to keep going left to right again to the third one, which I don't have an exhibit for, but you've heard me talk about some of the challenges of the unfunded lunch balances. You know, we've got an estimate of 80 in. That's starting to feel pretty good. I just touched base with Ernie. Don't hold me to it, a couple of weeks ago or a week and a half or so ago, and we're already mid-30s. So that's starting to feel like that's a pretty good number. So if you follow along, we started out with the $81 million budget. Just in the first bucket alone, we almost have $1.1 million of unexpected expenses that are sort of bleeding into our P&L. So then I thought I'd start to categorize what I consider sort of over budget expenses. So the first one, you know, fairly small, but I'm sharing these with you as I could start to explain to you some of the pieces of our P&L. So the first one is Exhibit 3. So these are full fiscal year 24 expenses that we've already paid that were not budgeted. I think a couple of these you've already heard me talk about. The large one in there is the grounds repair that we paid to the town. I do have that in the budget for next year. It's been an item forever. I'm just not sure why it was not in the budget for this year, but it's not there. So those have already been incurred. We've already paid those. We had a retirement that we had a small payout for as well. And then I thought I'd get you into some of the, some of the larger ones, I should say, that I have some estimates around. So that should be your exhibit. I think you probably have it as exhibit 5, but as exhibit 4, it's about $1 million of various costs here. I don't know if we have time to go through each one of these. I can certainly hit on a few big ones for sure. Summer school is one. So summer school, I've got about 80,000. And if you look at our budget, we just didn't have it funded well enough given the programs that we have. Building subs, about $200,000. We've added some building subs, so we've got a little bit of a higher cost there at the need at some of the elementary schools, especially. We have had some overtime. It might be a little bit of a high number, but early on, we've had some challenges in a few departments with key personnel and just trying to keep up with the work. I'll go into transportation. So you've heard me talk about transportation. We got really two pieces there. If you think about it, one is just a mix of the buses, where we anticipated a certain number of large buses and a certain number of small buses. And I think we've got one that's a little flipped. And then I've got an estimate in for athletics. I'm actually going to bring this one to the finance committee on Tuesday when we meet to get into a little more detail there as we try to get some of our invoices a little straight to the point where we can analyze those and get us to a better predictability. And then on the bottom, there's 3 in a row, the utilities, and every month I give you an update on the utility dashboard. And this is sort of my estimate of what I think the 3 look like in terms of finishing out this year. And it really, to keep it really simple, it gets those 3 accounts pretty similar to the thresholds that we experienced last year, which is kind of what I've been saying in each one of the board meetings. I think we're going to incur costs that are very similar to where we ended up last year. So,
Can I ask you a quick question? Not to interrupt, but so have we forecasted in the next budget to compensate for this?
I have.
Okay,
Yeah.
thank you.
I actually have for just about every item on this page.
Thank you.
I was like, look quickly. So, so here we have a set of sort of over budgeted expenses of about $1.1 million.
Did you
So if
want to
you look at
explain the mutual link?
Yeah, I wish Clint was on here, but
Yeah.
I know we got a grant to help pay for the majority of all of our, I'm going to call it sort of security cameras and peripherals. And this is the piece, the radios are the piece that fall on the board. The 45 is really going to depend on if we can get the entire system up and running this fiscal year, but at some point we're going to spend about $45,000 on radios.
Thank you.
Yep. So if you follow me up on the big sheet there, if you take our budget and add those 2 categories together, what we really needed was a budget of about $83,700,000. I'm just rounding. The next category is just, if you look at our P&L up and down, there's spots all over the entire P&L where you just, you never hit 0. So I've just tried to aggregate all those, on a net basis, about another $62,000. I could always get you into some of that detail, but I just felt like in aggregate, it just wasn't very material. So what that really means is, we're over budget by $2.254 million. It does not include healthcare. To put that caveat in, I put a little note on the bottom there. My assumption right now is anything that's over on healthcare would be funded by the reserve. To give you a little good news on healthcare, we did have a really good month this last month. It was actually lower than last year. It's the first month of our fiscal year that we've had a claim a claim cost come in that was lower than the prior fiscal year. So that's good news for us as we start to get into the winter months. So hopefully you followed along there, but just call it, 2.2, $2.3 million overage, really in the two buckets that I outlined. And then I just went through as I've been sort of studying the P&L and just trying to outline some opportunities for us. We haven't pulled any of these levers for the most part. I just wanted to kind of throw it out there in terms of where we can start to look. And in no particular order at all, the site budgets at the schools, currently right now we're holding back 40%. If we gave them another 10% to get them through the rest of the year and held back 30%, that would give us, roughly 246,000. We have the DoD supplemental. There is some balance there. I know historically it's been used for technology. I kind of isolated this in really two buckets, really to help us with, if we decided to use it, really to help us with our transportation costs that have been a real struggle for us. That's the first line. And then the second line is really the anticipated electricity costs as well as the unfunded lunch balances. Third one is impact aid. We did receive sort of a special payment from the government around impact aid for students with disabilities. So that's why you see that on purchase services. I thought we can use that specifically to help Denise and her organization with some of the assessments and OTPT services that she has. And then I had another exhibit, which is just called operations, with, sort of a variety of different opportunities for us to take a look at, and I need to do a little more studying myself in terms of, excuse me, how all these would play out. But there's certainly some opportunities there that could help us as well. So just for discussion purposes, I sort of organized all these opportunities. And, potentially that's $1.8 million of opportunities for us if all those played out, which would leave us with, a shortfall of, call it 400,000. The uncertainty in here is some of the things I started with by telling you that, I'm still receiving invoices from last year. And I get surprised every time that happens. The second thing is, it's sort of like what I don't know. I've been in 4 months. I haven't even been through a cycle yet, but I'm trying to get a good lens and something that we can all start to manage for and understand, at least from a goalpost, what the year is starting to look like. Couple more opportunities here that aren't really on the page yet, but the 406 is an interesting number because we did get an extra payment for impact aid of 138,000 that went to the town. That certainly could have helped us now that I look back on this. That would get us almost into the high twos at least. And I think, that's sort of it in summary. I can certainly answer some questions for you if that would be helpful. So
Dave,
if I could, Jay, if I can make just one more statement. So my friends on the finance committee, just to give you a couple things that have changed since we last spoke. So one is we talked about unemployment. We did get our second quarter unemployment bill just the other day. I mentioned in that meeting we're expected to be a little lower. We are still going to be lower, but certainly not to the extent that we were initially anticipating. It was a few $1,000s higher than our first quarter. The second thing is the invoices I just mentioned. One was a bus invoice, another was I think it was assessment invoice. So that was about $45,000. The third was in my initial estimate that I'd shared with you, I had the assumption of the 1 hour of the tutor opportunity that we were originally planning on. So taking that out, just sort of reversing that, was about 251,000. So those are sort of the big three. And then the rest of it is really just me spending some more time and updating numbers over the last week. So sorry, Jay, I just wanted to give that.
Sure. I would like to know, I think we talked about this at one point, but there's another possible income stream that I believe comes in May. The special education excess cost reimbursement, which, as I understand it, comes directly to the district, does not go through the town like impact aid has been. And I'm just wondering if we have any handle on, I think the claim has to be filed in December, but then I think you mentioned there might be some changes to that. So do we
Yes.
have any estimate on special education excess
It's a
costs?
two-pronged process, right? You do an initial filing in December and then you do a true up in the spring. You know, the last, I could tell you, I can give you a couple data points. You know, last year meaning 2023, we budgeted a little bit too high based on what we received. But if you look at 22 and 21, we under budgeted by at least 200,000. I want to say 225,000. So that balance went to the town. This year, I felt pretty good about it, you know, in terms of the number. I'm just not sure how the funding is going to be. It sounds like the state is potentially reconsidering the funding levels for us. So if you're, without getting into details, I could show you the way this thing works at some point, but all towns end up in some sort of quadrant per se based on a wealth factor. You know, ours would put us in a position where we'd receive about 88% reimbursement. I think right now it's heading towards around 63, 64%, if that's the way it plays out. So I have that on my radar. That's about $140,000 less if that's indeed going to be the case.
But what 63% of what figure though?
Yeah, so it's what you do is you have to add up all your excess costs related to students with special needs.
Right.
And then depending on if they're board placed or state placed, you get a certain level of reimbursement on those. They're different levels. So you add that up, and let's say your out-of-pocket expenses were $1 million. Generally, given our wealth factor, we'd get 888,000 at 88%. Right now, it sounds like we could be down in that low 60% range, 63, 64.
64% of 880 excess cost?
Nope, 64% of what your eligible excess costs are for reimbursement. Yeah,
Okay.
because
Alright.
no one's ever funded at 100%.
Right. And when will we know what that final figure is?
I have the figure. What I'm trying to figure out now is
What they're gonna.
this really what the state's going to hold us to?
Yeah.
I have the number. I've done the math. I have the number. I just need to find out now if this is going to be, if this really where the state is heading. And I'm literally about 2 days into this, so I just don't have an update for you yet.
Okay. All right. Next I'll recognize Jen and then Dean.
Hi there. Good evening, everyone. Just a couple of questions. And Dave, I know it's not your fault because you weren't here a full cycle, but I think we need to look at having like an open commitment report that will take into account that when we deal with vendors, that we need to track it so that we don't have these unexpected costs from prior period. So maybe that's something that we can either enhance going forward so we don't have this issue in 2025. That's a comment. Second, for opportunities, I would like a column added, you know, just for discussion purposes. The ARP ESSER individuals or costs that are included in the 24 budget, because that's definitely a discussion point and we can't assume that that's moving forward.
Thanks, Jen. If I could just respond real quick. Relevant to ARP ESSER, so I have not had the opportunity to go back and try to rebalance this now that we've made a few of these changes. So I at one point, if you remember, I was saying we were balanced in a good spot. I'm not sure if that's the case anymore because it's pretty heavily occupied with some of the tutors. So need to do a little homework on that. And then I think your first comment is very valid. And we've already talked internally about, just some business processes that you start to implement as you get closer to year end, in terms of like having sponsors associated with vendors so we can have a reach out and a clear communication. I'm almost used to sending vendors, kind of like an audit letter, which tells them, for them to obligate and tell us in writing what our obligations are going into that next fiscal year. So there's a couple things I think we can work on for sure.
Perfect. Thank you.
Dean?
Yeah, so, as far back as I can remember, the budgets have been kind of a squeaker. We rarely land, in a lot of clover. We make it in, there may be $10,000 left over, and we pat ourselves on the back that we came in about on budget. I don't remember ever seeing an underage. This, if you want to do a PR, $400,000 out of an $81 million budget is a hair less than 0.5%. But it is a big number and it's a negative number. But what jumps out at me is the expenses from last year. There's always something that shows up after June 30th. I get that. But one, we're still getting bills. I don't know that we're going to keep getting bills. I hope we don't. And if we do, send them back. We're not here. We're not home. But wow, that's a large number. $760,000 of, oh, by the way, added on. That means that the fiscal year ending 23 budget was way off, or it was way off. And so I don't know, either there was a problem with the estimate, or there was overspending somewhere, or there was a surprise in 23 as well. The property costs I get, but was there, it's just staggering. I expect that there's going to be something unexpected, but that's a large number. So that means if we've based any budget, any subsequent budget based on our paper performance, I mean, yeah, you may have answered this one. So going forward, you're accounting for the fact that, we spent $700,000 more last year, so we should keep that in mind for this year, or are we pretending that that didn't happen for this year?
No, I mean, in the estimate, I'm accounting for that because I have to make up for that, right? And I
Yeah.
totally agree, it's a big number. What I'm trying to do is really a couple things, Dean, and we start to talk about this in finance committee, is, implement some internal business process to really tackle that as we get to year end. And let's not just close the book and assume we know everything. Because when you look at that 758, a big chunk of that, again, I'm a broken record on this, but it's in transportation. Right, that's the invoice I just received this week. It was a $40,000 transportation invoice. So, we need to build some partnership with these folks and let them understand that this is just not acceptable for us.
So the bus company that we've been working with all this time, all these years, that we had problems with, that we worked out, they happen to be one of two vendors that are capable of actually giving us the buses we need because we need 40 plus buses, etc. That outfit said, oh, by the way, we forgot to bill you for last year.
Yeah, and we're gonna talk about some challenges I'm having this year at the finance committee, because I'm still not satisfied with what I'm getting.
I think they have us over a barrel, or they think they have us over a barrel because where are we going to go? Where are we going to get another 40 buses? Right?
Yeah.
I don't like that.
Yeah. And the other thing, Dean, just while we're on this, so I'm being a little prescriptive as I go through this, and we start to get into this in finance committee too, because I'm really trying to get us to a point that we end this year with at a zero or as close as possible, just knowing the challenges we have going forward. I get it's a struggle, but I think through a lot of us talking about it and just partnering as we go through this, we can get close. So I want to start to share it now and start to think about, the appropriate levers.
Yeah. All right. Thanks.
Next, I'll recognize Adrian.
Hi. So I would kind of like to, you know, kind of reiterate what Jen had said about opportunities, and we are going to have to talk about, you know, whether we're going to carry all those grant positions next year, you know, in the next month. So maybe if those are expired positions and we're no longer obligated, we should maybe talk about some of those as part of this. And then second, maybe Susan can answer this. But are there any other grant positions that have expired this year, will be expiring this year, that, you know, the board hasn't committed to? So are any grants being turned into, you know, personnel, you know, that the school district it will now be taking on?
No, the our Besser is the main challenge. And I think we do need to look at it carefully. Adrian, I do agree with both you and Jen. We have to really carefully figure out what is going to next year for operations or what isn't going to go and when does it go. So I agree.
All right, so that, but there are no other grant positions that expired this year or will be expiring this year?
No other closeouts this year.
All right.
And Adrian, I think you had a question on this before, so I put together a schedule for it. It just shows you all the grants that have FTEs in them and when those
Yeah,
expirations are, so you can take a look at it.
All right, good. Yeah, I haven't seen that yet, but
Yep.
and then the other thing I wanted to kind of mention is the Fitch insurance claim that's 73,971. Now that we know the water came from the sky and not the ground, are we expecting that insurance is going to cover that now?
So not sure yet because they've been balking on it. So we're going to give them some language now around our findings. And hopefully that'll help get us over the guardrails. And this one's been tough because early on, we didn't really have findings. Belfour came in and they didn't really have an answer for us. Now that we've been through the walls and Sam has an answer, he's going to put together a few sentences for me that I'm going to share with our broker. So I'm hoping so.
All right. I mean, maybe it's worth having somebody that specializes, like an outside contract, just because it's something I do for boats. But maybe if there's an outside profession, because it is, I mean, it's going to be almost $50,000, that insurance check. So maybe it's something that, you know, we should see if we can hire a specialist to come in and give an outside independent evaluation, given all the facts that we have. And that way, rather than just something that's kind of one-sided opinion from us as a district, becomes a third-party opinion from an independent company.
Yeah, that's a good idea.
All right, and that's all I had. Thank you.
Okay, thank you. Next, I'll recognize Matthew.
Thank you, Jay. I have three quick questions. Did I understand correctly that restoring the tutors was a cost of about $250,000?
That is correct.
Thank you. I'm still trying to get a handle on the healthcare or potential healthcare impact. I may be mistaken, but I thought there were two components to that. The first being the employee share of the utilization of services, and the second portion being whether or not the administrator was going to do it for the same fee, less or more. A, am I correct in understanding the components? And B, are we at a point that we can even estimate what those costs or increase or decreases would be with regard to all these other figures that you have?
Yes. So couple responses. Your first assumption is correct. There's, the contributions can consist of obviously the board making a contribution and then the employee contribution as well. I think the employee, don't hold me exactly, Matthew, but it's something like $2+ million for employees. And then the board is, I think last year was about 5.7 million or so. And then remember, we also make some HSA contributions as well. I was actually working on that yesterday, so I'm a day behind with this issue that we had overnight here. So I lost a day's worth of work, but I have that estimate that I'm going to piece together. What I'd like to share with the board is just kind of a walkthrough like this. Like, here's where we started last year with our pick around our health insurance, how much we were going to contribute and what the claims are looking like, and then give you a couple options based on what our renewal team has shared with us. So the board can think about, you know, the guardrails again in terms of a high and low and for the budget for next year. So I'm a day or two away from that.
Thank you very much. The final thing is a follow up on what the issue that Adrian brought out with regard how can the board make reflective decisions on the number of expiring ARPS or employment slots that we're going to bring over to our budget. At the last meeting, I handed out a very rough first pass at a template. Is there some way that we'll be able to get some kind of visualization on the, I think Adrian broadened it out, not just ARPS, but any grant employment that is expiring that might move over, something that we could look at later on, not tonight, obviously.
Yep. So as I mentioned to Adrian, I have a schedule. It's already completed that will show you the remainder of our grants and how many FTEs are in each one of those and what their expiration dates are. Because, you know, there's a variety, right? It's all the way from an entitlement grant to a competitive grant. So I have that for you. And then in our budget book, I believe, or at least in the presentation, I shared with you how many positions are in ARP that, at least for our initial stab, you know, we're estimated to come over to the board for next year.
Mm-hmm. Thank you.
So a question for you, Susan. I'm sure this probably goes without saying, but I assume that we're continuing to look at every opportunity to only spend money where it's absolutely necessary in the current year.
That's correct.
And, you know, obviously, you know, my personal hope would be that it's has the least impact on anything directly for students. You
Right.
know, if we can put off some software purchases or leases into next year, they're not going to directly impact students and look for other ways to just spend what's absolutely necessary at this point. And then the next thing is, I know that Dave has been working with the town so that we can get an accurate figure on the insurance reserve, so we know what buffer we have as these reports continue to come in through the end of the year, between the reserve and the corridor for the current year. And I know that's been a challenge, getting those figures from the town. And I don't want to put a lot of pressure. I know you have a lot of things coming at you at once, Dave, but if we can get something maybe for the next finance meeting that gets us a little bit closer to what those true figures are.
Yeah, Jay, so I feel really good about the June 30 number. And I know that seems like a long time ago. The town is sending me updates. They sent me one the other day that got me through October. I don't feel good about it though. I still don't think it's right. So
He's
it's
worried
really
about
capacity, Jay, unfortunately, for me to keep going back and talking to my team and
Right.
you know, do these reconciliations. I just don't think that's a good number. So I've got to your point, I got to spend a little more time on it, but it's getting there. But I feel good about the June number. I don't feel good about the October number.
Okay. Yeah, well, I know you have a lot on your plate, but it would be good to know, you know, where we actually stand with that in the current year. And again, that goes without saying. Are there any other questions about the challenges that we're facing for the current year budget? Oh, I'm sorry, Dean, I couldn't see the hand. You just need to hit that little unmute button.
This has to do with the plumbing appliances that failed because the water pressure was too high. There is an amount for which we'll be held responsible. We're going to be out of pocket X dollars. Is that going to be that $54,000?
Dean, so that's our gross cost that we've already paid.
Okay.
It's already been filed with the insurance company. So out of pocket, hopefully it will be 25 and we get the net difference back.
Yeah, I was gonna say, because no matter what we're out of pocket, if it's something in the 5-figure range, it still bothers me that somebody should have known the water pressure was too high. That should have been compensated for so that we wouldn't have the problem with the appliances. Either they shouldn't have been specified because there was a presumption about the water pressure that shouldn't have been made, or there was something that should have been added to the appliances. They're fine, but something should have been added, some sort of an adapter or something, so that the water pressure wouldn't have blown them out and caused the damage that it did. But as a school district, I don't know as I sit here that we have responsibility for that. So we have our own insurance carrier covering this. And I think maybe somebody else has an insurance carrier we can talk to. I don't know whether it's the contractor, supplier, the designer, somebody. I'd like that explored, because hey, even if it's $25,000, it's $25,000. So
Yeah, and Dean, you did bring that up at a finance meeting, and I am still curious about whether there's something, I mean, obviously the town built the building. So is there someone we could talk to at the town about, you know, the responsibility of contractors or subcontractors to, you know, to know what the water pressure should have been. I mean, in one respect, we've already submitted to the insurance, but you know, I don't know if that's something could be pulled back. I mean, is there somebody at the town, you know, that we could talk to about that?
right. Well, somebody specified the appliances, and somebody must have told somebody, or should have told somebody, or somebody must have investigated what is the water pressure. What do we have to do so these things don't? Because if that's what happened, the water pressure was too high, higher than expected, and if it was known ahead of time, who should have known that? Who knew that, and why wasn't that taken care of? And it may be all on us. Maybe we gave the designer or the supplier or the contractor the wrong number. We gave them the wrong impression. But you know, I'm thinking if it's a relatively small number, you may not even have to get to the point where you have to prove the claim in front of a judge. I think you'd be talking to an insurance adjuster. Just to be, you know, clear about that.
We did pose the question to John Burt, you know, who is the town manager. And there was a town building committee, as you recall, that kind of oversaw and worked closely with the construction company. And
Right.
so we did make it known, you know, and ask the question, is this something that happened due to construction or malfunction or whatever? Like you said, specifications on water pressure. But I really didn't get a solid answer back.
Before
Mm-hmm.
I know people are busy, they got a lot to do, but I just haven't, this bothers me. It's a rock in my ship.
I understand. It bothers me too.
And before I recognize Adrian, I know you had your hand up. Susan, is there any more discussion with John with regard to helping with the insurance deductibles?
Yes, we're still working through some of that at this point. So, you know, I plan on meeting with him again, probably next week, because we've been trying to meet on a regular basis. So trying to work through that.
Okay. All right. Thank you. And Adrian, did you have?
Yeah, just a quick comment. I think as far as where we should start, Dean, is just asking whoever in the building or town department to just look at the plans and specs and see if a pressure reducing valve was called out, and see if the pressure was supposed to be tested. That would be at least I talked to somebody that I know about it, and that would be the place to start. So that might be something we can just do inside, read the documents, and see if that's called out in the documents.
Yeah, no, definitely. That's something we
Thank
should
you.
do in-house first. Yeah.
Okay. Any other questions about the 2024 budget challenges we've been discussing? We do have
Lloyd is here.
Warrant Attorney Floyd Dugas will be addressing some issues. Oh, Ian, did you have something?
Yeah, I just wanted to be sure that I know I came in late, so I don't want to take up any more time with that. But the documents about grant positions, that would be something that would be shared with the whole board.
Yeah.
Absolutely. Yeah, it's going up in the
Okay.
FAQ.
Very good, thank you. Oh, and was there any discussion about like the travel costs as far as like to conferences and things like that, as far as areas where there could be possible cuts?
I think a lot of that's being held back anyway at the site budget level, and Dr. Piazza and I are monitoring that at the central office level.
Okay, thank you.
Okay, obviously, we'll be hearing more about that. But we do have Attorney Floyd Dugas with us, the board attorney. And first of all, I'd just like to introduce Floyd. He's been the board attorney now, well, certainly since I've been on the board. But CABE does recommend that we annually meet and discuss board roles and responsibilities. So this is sort of part of our professional development. And I've also asked Floyd if he could address certain questions revolving around freedom of information, because I know that we have lots of questions about that, and that it's been in flux in the age of remote meetings. So with no further ado, Mr. Dugas.
Thank you, Jay, and good evening, everybody. So I'm breaking this into two components. The first is a drive-by version of a much longer board orientation that I've done for a number of districts, focusing specifically on the roles and responsibilities, but there are a couple other things I want to highlight, and hopefully I forwarded earlier a copy of the materials so that at your leisure you can go through that and get a better sense. And then I'll take a pause there for any questions about anything I've addressed under roles and responsibilities, and then I'll talk a little bit more specifically about the Freedom of Information Act. I'll do a brief overview, but then talk specifically about the new rules, if you will, regarding remote meetings such as this, and again try to entertain questions after that segment is done. I'm going to try to be as concise as I can. As I said, the first part and the materials I sent to you are part of a new board member orientation I have done for a number of years. Thank you. A number of years for many different school districts, or a number of different school districts throughout the state. So I want to make that point because nothing that I'm saying here is in response to anything that's happened recently in Groton. And I would say that if you check with CABE, if you check with the National School Board Association, if any board attorney, I think, would agree with the same points that are in here, at least in terms of the roles and responsibilities. So with that introduction, the first thing I want to talk, and I'm on B1 and B2 here, is, you know, where does your authority and responsibility come from, and your roles? And essentially, it starts with the state constitution, Article 1, Section 8, that guarantees students a free public education in this state. And so the question becomes, you know, so if that's in the Constitution and it's an obligation of the state, why are you guys doing what you do? And the answer is, and I'll show you the statutes in a moment, that the state has delegated its responsibility to you, to local and regional boards of education, and that's essentially the answer. So over the years, that has given rise to a question. I'm on number 2 here, which is basically, are you an agent of the town, or are you an agent of the state? And the short answer is, you are actually an agent of the state, responsible for carrying out the responsibilities that it has delegated to you. However, you are subject to local charter as long as it doesn't conflict with the core educational responsibilities that you have to carry out. So to give you an example, the town can incorporate a purchasing policy. That doesn't necessarily go to the core role of educating children, as long as it doesn't somehow interfere with it. And you would have to comply with the local charter. Otherwise, your responsibilities are laid out in state statutes. The very high level, some of the key statutes here are 10-220, and that's really where the state has delegated the responsibility to you and other local and regional boards of ed to maintain good public and secondary schools and to implement the quote unquote education interests of the state. Good luck finding a definition on that. The state seems to invoke it anytime it thinks you're not following one of its statutes or mandates. But that's, you know, and there's some fairly detailed information in there about providing books and a safe school and so on and so forth. But that's the broad delegation and mandate. And generally speaking, when you adopt a budget that provides for books and, you know, and all of that, teachers and so forth, that's how you're really satisfying your obligation under 10-220. Then 10-221, some folks would say is really the core of your duties and responsibilities when you sit as a board. And what this does is it gives you broad authority to adopt policies for the management and discipline of the schools, essentially for the running of the schools. You effectively develop the policy, and as I'll talk about shortly, then it's up to the superintendent and the employees in the district to carry that out. But your role is to develop the policies. 10-222 is a statute that just talks about the budget process. You guys have obviously been talking about that quite a bit. Importantly, I would note that once you receive an appropriation from the town, you are free to spend it as you see fit. There's been case law over the years where towns have tried to dictate how you spend your money, whether it's capital issues, whether it's how many teachers you have and principals, and they cannot do that. Once you've received your appropriation, it's yours to spend. This next bullet point is an important one, particularly based on the issue that happened relative, and I watched the meeting relative to the tutors. It says you may not expend the may not exceed the appropriation, and if you do so, you are, as board members, you are liable. Now, there's actually two statutes. It's 348 and 349, and it talks about public officers. But there's a case law, including a Supreme Court decision, where the court basically says it wasn't the direct issue in the case, but the court says, and of course, if a Board of Education were to overspend its budget, its members would be personally liable. Okay. Now, what I'll tell you is that's something that is rarely invoked. It would actually require somebody, could be a member of the public, would have standing, could be the town, but somebody would have to bring a lawsuit to enforce that. But I think it's important you understand that you have individual liability. Arguably, this applies to the superintendent and anybody else who's in the direct stream. But importantly, you guys need to be very concerned about that. Particularly, I came into the sort of the middle of David's presentation, but I understand there's a deficit, a fairly significant deficit, and understand that at least in theory, there is potential liability for you folks, and you need to make sure that at the end of the year, that deficit is wiped out, or that you go to the town and get a supplemental appropriation in order to make sure at the end of the day that the budget balances out. Let's go. Thank you. Scroll down a little further. I would just simply point out, which I'm sure all of you know, the town actually owns the buildings, all of your buildings. But as long as it's being used for educational purposes, and that of course includes a central office, as long as it's being used for educational purposes, you have the right to control it. You have the right to decide who can use it, whether the rec department can or can't, and so on and so forth. So those are sort of the key legal provisions. The other sort of law, if you will, and I put that in quotes, are your bylaws. And the bylaws are your agreed upon rules as to how you will conduct yourselves. They don't go to some of the things that those other statutes do specifically. I mean, obviously there's some verbiage in there, I believe, about the budget process and so forth, but those really govern how you do things, and those are extremely important that you follow them, extremely important that you keep them up to date, as is the case with all of your board policies, and something I commend new board members all the time. It's one of the sort of the first things you should look at and become familiar with as you go on. The other key area I focus on is the Freedom of Information Act. I'm going to skip that now because I'm going to get into that in more detail later. In terms of individual board member qualifications and so forth, got to be 18 years of age, and you've got to be a resident of the town. Importantly, you cannot, your employment is prohibited. You cannot be employed by the board in any capacity. You can volunteer, gets a little dicey in a number of respects, but you can volunteer, but you cannot have any kind of a paid position. I mentioned briefly here the ethics ordinance. We don't have time to get into that deeply, just to be aware that there is an ethics ordinance in town. You are subject to it and should be familiar with it. For the most part, it deals with things like direct, personal dealings where you try to use your role in the board for a financial gain of some kind. If you have a financial interest in something, your company is bidding on a project, you have to disclose that sort of thing. But I would commend you to look at that. Legal exposure. What I sometimes say to new board members, and sometimes I'm reluctant to say it, but if you're on a board of education, the chances are pretty good, sometime during your tenure, you will be sued. Now, you'll be sued because you're a member of the board, but you may be named personally. But the good news is there are a number of protections for you. The first is there's a statute 10-235 pursuant to which you, and by the way, all employees of the school district are indemnified for any liability that may come your way, as long as your actions aren't arbitrary, capricious, or reckless. And the example I use is you come on the board and you say, boy, I want to get that employee Sam Smith out. I hope there's no Sam Smiths, but I really want to stick it to that Sam Smith because he, divorced my sister or something, and or my neighbor, and I can't stand him. And you start doing things that are targeted, at that. That's where the kind of thing where you might lose your protection. Another area where you might lose protection is if you slander somebody or libel somebody. There's a separate statute I haven't listed here, but it essentially says that a municipal officer cannot be indemnified if they in fact slander somebody. So obviously you want to be careful about remarks you might make about somebody. Next major point, sometimes a little surprise to new board members, but when you're not in a meeting like this, you have no authority, no power. You only have authority and power when you're sitting as a board, duly called and take a vote and take a particular action. How can we scroll down? I'm going to skip over this next piece. So let me go to the board's function, just a little deeper dive. The board's, as I mentioned, your primary role is to promulgate policy. And what you should do is in consultation with the superintendent, develop a vision for the district. You should set goals based on that vision. You should formulate policy to accomplish those goals. You should evaluate whether you're achieving the goals and whether the policies need to be amended. If the policies aren't being, satisfactory, then obviously you need to amend the policies. But importantly, your role is to set the policy. It is the administration's responsibility to implement those policies. Okay. I mentioned point 2 here, so I'll just skip over number 3, another primary responsibility you have under the statutes is to hire and evaluate the superintendent. And what is often said is you have one employee and one employee only, and that's the superintendent of schools. Everybody else in the district, assistant superintendent, principals, teachers, paras, they are the responsibility, and the superintendent has responsibility for, unless you have a specific policy that says something else, responsibility for hiring, firing, evaluating, directing those employees. Having said that, one specific statutory duty you have is the duty to collectively bargain with your unions. Typically, what will happen is myself, the business manager, and the superintendent, and delegates from the Board of Ed will sit in on those negotiations. They are your liaison. But importantly, once there is an agreement, it comes back to you for approval. And until that's happened, there's nothing binding. So usually if we have a tentative agreement, it's with the clear understanding, union rank and file has to vote on it, but also it has to be approved by you. These next things, student expulsions, student accommodation hearings, residency, bus stop disputes, grievances, those are all, the student expulsions and the school accommodations by statute, you have a role pursuant to the grievance hearings. That's usually by virtue of a collective bargaining agreement. And if and when we've got a grievance, we'll certainly bring that, I'll bring you up to speed on what that process is about. Terminating teachers are an animal in and to themselves. Unlike most employees where their termination is governed by the collective bargaining agreement, with teachers, there is a statute. Anybody who's interested, it's 10-151. And it is said, and I agree, it is one of the most pro-employee protections that there is for any employees. So in the private sector, we've got minimal protection. Unless you're in a union, you have some. In the private sector, there's much greater protections, but in the private sector, nobody has greater protections against termination than teachers, and there's a very specific process. In that process, what happens is the superintendent initiates it. The employee has the option to go to either an independent hearing officer or to you. 95% of the time, they go to an independent hearing officer. The hearing officer will make findings of fact and recommendations. If the superintendent's recommending termination, they could come back and say, nah, I don't think so. Or they could say termination or something less. That decision then comes to you. And you have to make either decide to accept the recommendation or not. And so what we say is that when you're sitting in that capacity, you serve in what's known as a quasi-judicial capacity. You're like a judge might be. And when public sector employees, unlike those of us who work in the private sector, are entitled to a constitutional right to their job. Now, what that means as a practical matter is they're entitled to due process, substantive due process, meaning you've got to have a good reason, not an arbitrary one, and procedural, you've got to adhere to certain procedures when you terminate them. And part of that is that when they come before you, if we have a teacher that goes the distance and we have a hearing and the recommendation comes to you, they're entitled to an impartial decision maker. And that means you haven't made up your mind. And there have been cases over the year where, people have gotten so much information that they could not have formed an opinion. So for that reason, if we were in this process, you would find that even though you'd want to have a lot of detail and information on that, you can't. And the reason is we don't want to run the risk that the employee argues that their rights were violated and undo the whole process after 6 months and tens of thousands of dollars in the process. So just understand that's a particularly sensitive process and you would not get that information, and that's the reason why. Chain of command, very simple. School districts work best when a chain of command is followed. A parent approaches you and says, such and such is going on in my child's classroom. My child's teacher isn't recording grades and getting back to me. The chain of command should be followed. Which means first, telling them to go talk to the teacher. If that isn't satisfactory, you go talk to the principal. If you don't get anywhere with the principal, you just follow the chain of command. You really shouldn't be getting directly involved. About once a year, I get a board member who just gets they become an advocate essentially for the party. And at that point in time, we're in that situation where it's argued that you can't be unbiased. And if the matter comes before you, whether it's a student expulsion, whether it's a teacher termination, whether it's other discipline for other employees, it creates problems. And that's for that reason, it should be referred to the chain of command. You may hear the term FERPA, Family Education Right to Privacy Act. It essentially says only those with a need to know should have access to personally identifiable information about a child, grades, even certainly their status in terms of disabilities. So you should really, except in the context of an expulsion hearing, for example, you should never have access to that sort of information. Staff, generally the same rule, although it's not embedded in statute, but there are reasons why the same thing when it comes to staff matters. You shouldn't be involved in, should let the superintendent manage that. If I could go down now to superintendent's function, there is a statute 10-157. This is the statute that gives the superintendent broad authority. It essentially provides that the superintendent is the one responsible for the day-to-day supervision of the schools. It's an odd term, but they refer to the superintendent as the chief executive officer of the board. Provides that the superintendent supervises and evaluates all staff, and serves as a liaison between the board and staff, and so forth. But what it really boils down to is, other than a specific duty, which I have touched on, the superintendent is responsible for the day-to-day operation of the school district, and board members should not be involved in the day-to-day operation of the district. Now, having said that, boards will sometimes, and there's nothing illegal or wrong about it, boards will carve out certain things for themselves. So to give you an example, there's a statute for hiring certified staff, teachers and administrators. And what that basically allows you to do is to have a role in the hiring process if you want. And I've seen it ranges from districts saying nothing and just letting the superintendent hire everybody to requiring that certified staff, for example, be presented for the board for approval, to kind of middle ground positions, which is, well, just administrative positions, assistant superintendent, assistant principals on up. So it runs the gamut. There are pros and cons to each approach, but you know, so you can carve out sort of pieces. Let me give you another example. In theory, the superintendent has the authority to enter into a contract on behalf of the district with or without your approval, but there are board policies that say, for example, any contract over 50,000, or I've seen even as low as 10,000, has to be approved by the board. Those are the types of things you can do that can pull back some of the duties and responsibilities that otherwise would fall in the superintendent. But generally, that really should only happen when there's a specific policy that does that. Generally speaking, I mentioned there's a statute governing your ability to carve out approval of teachers and administrators. There is not a similar statute for the hiring of non-certified staff. So the hiring of non-certified staff, the supervision and so forth, clearly falls under the responsibility of the superintendent. If I could go down, mention some other things here you can take a look at, but under F, and I'm not going to go through this because this would take quite a bit of time, but I should have credited CABE. This is a roles and responsibilities that CABE has come up with that I've borrowed from. It's good. It's a good thing to go through when you have a few minutes just to get the sense of what the superintendent's responsibilities are and your responsibilities are. But just to give you kind of a couple examples, to go to page 7. Yep. So here we go. Yep. And this will be the 1, 2, 3. So the third bullet down, to seek the superintendent's recommendation before taking action. That's the superintendent, that's your role. And the superintendent's role is to provide the board with, I can't see, well-informed recommendation. So it should be a recommendation from the superintendent, and then you take action based on the recommendation. The 1, 2, 3, 4, 5, 6 bullet down, to delegate, it's a very bottom one there, if you could scroll up, and thank you. To delegate to the superintendent responsibility for all administrative functions except for those specifically reserved to the board through board policy. That's your responsibility. And then, of course, on the other side, the superintendent is to oversee the organization and management of the district's day-to-day operations. But again, I encourage you to go through that to get a better sense of whose duties. I hate the expression, but you know, whose lane is which lane. And you know, part of this, I should say, is based on in part on statutes that we've talked about, but I would say mostly this is based on, you know, what happens throughout the country, how school boards and administrations work. And for the most part, I've been doing this for over 35 years. I would say when folks adhere to these roles and responsibilities, things tend to work better, best, I should say. So that's it in terms of just briefly on the role and responsibility of the board attorney, which is at the bottom part of page 8. You know, we will work, look, thank you. We will work closely with the administration. Most of what we will do through the administration, but it's important to point out, and Susan certainly knows this, but we represent the board. Okay, we are your attorney. We're also the attorney for, you know, the Groton Public Schools, but but, you know, we don't represent the administration. We represent the board, and we also, we provide advice. You know, we don't make decisions. Sometimes people will look to us for a decision, and I have to say to them, it's not my job. If you want my opinion, I'll give you my opinion, but it's not my role. We don't represent individual board members. We can't give you advice individually. But, you know, if you're sued and we are asked to defend, you know, the board members, obviously we would do that. And so that's our role. So that's a brief overview of the roles and responsibilities. I will stop here and answer any questions you have before I get into the FOIA component.
I will recognize Ian.
Thank you. Thank you, Mr. Dugas, for the presentation. You skipped over section 6 as far as like the individual board member section, and where action is as a private citizen, not as a board member.
Sure.
But I was hoping to hear a little bit more about that section.
Sure. Let me just find it. Normally, this presentation itself is about an hour, hour and a half. So I was just trying to hit some highlights. Oh, yeah. So, actions as a private citizen. So, you know, there's a concept when we talk about students and what their rights are. And, you know, students don't leave their rights at the schoolhouse door. And that's, you know, for things like First Amendment and so forth. But, you know, the same is true of board members. You don't have to be a monolith. You are entitled to your own, you know, opinions. But what we ask is, if you are making a public statement, I'm not talking at a board meeting, but a public statement, that you try to make clear that you are speaking in your own individual capacity and not as a member of the board. Sometimes people will have these days, they might have a blog, you know, BOE Floyd or something like that, and, you know, say such and such should happen or so on and so forth. And sometimes, you know, the public has a difficult time. They don't understand what I've just explained to you, that you only act as a board, and they think, you know, if you say something, then that's you know, speaking on behalf of the board. So we ask that you try to couch it in terms of that. At these meetings, obviously, everybody is entitled to express their opinion on a matter. That everybody should be entitled to express their opinion. Maybe you shouldn't be allowed to go on for 2.5 hours at a board meeting about an issue, and there are mechanisms for making sure that that doesn't happen, but you certainly can and should. Again, the dogma is that, however, once a decision is made, you should accept the decision and move on. You know, we don't win all of our points and arguments, but you know, and folks shouldn't be out there saying, well, that was a stupid decision, I disagree with it, and it just creates disharmony and confusion on the part of the public. But you know, that again, that's just what years of being involved in this business has said, not just to me, to other folks. You obviously are entitled to your own opinions. I don't want to get into the FOI issue just yet, because I'll get into that. Hopefully answers your question, Mr. Thomas.
Yeah, so basically, like, if someone was inclined to do to express an opinion somewhere, it would have to be done just with like a series of disclaimers woven throughout the opinion.
Yeah, I wouldn't even say woven throughout, but it's just, as long as you make clear you're expressing your own opinion and it's not the opinion of the board itself, that would be really helpful.
Understood. That seems fair. And the letter D of that section, would you mind just elaborating on that a little bit?
You talk about the board function?
Participation in PTOs?
Oh, I'm sorry. Yeah. The only reason I included this, I've been tempted to take it out, is because a couple years ago, this was an issue and CABE issued a position statement that basically said, or at least it was advising that folks should not participate in PTOs or parent, similar organizations. I'll sit here, I'll tell you that there is no law prohibiting it. The reason CABE recommended that, well, it was for a couple of reasons. One of which was that sometimes, particularly when you have somebody who comes from this background, they tend to be focused on their particular school or their kid's school as opposed to what's best for the whole district. And the theory is you should be making decisions that are what's in the best interest of all the children of Groton, not just the children at one particular school. And so anyway, I think that's where CABE came from. I would never tell somebody don't, and I certainly wouldn't say you can't go to meetings and listen, because that's a good, place to get good intel and feedback and so forth. But to have any kind of a leadership role tends to run contrary to what you're supposed to be doing. Or it can.
Understood. Yeah. So PTOs, would that also include like booster clubs and things like that?
Yes. Again, same thing. Best that you now have a leadership role of any kind. But if your child happens to be into robotics and you want to, go to the meeting and listen to what folks have to say, again, you're not there as a representative of the board. You're really there as a parent, but you're listening. That sort of thing I think is fine.
All right. And if this role existed before an election to the board, there's, some people are part of these things and then they end up elected.
No, it happens a lot, actually. Yeah.
But yeah, again, I think also just like, holding a firm but fine line between the roles. Like you said, it's not illegal. It's just you have to be very disciplined in how you approach and engage with people on which hat you're wearing.
A great analogy. I was just going to use the hat analogy. Yeah.
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 All right. Well, thank you for that.
You're welcome.
Do we have any other questions for Floyd about this section before we get into the FOI? Okay, if not, if you want to.
Yep.
Floyd?
Sure. Somebody wants to pull up the FOI presentation. Again, all right, well, let me try to hit the highlights and then get into questions, because again, this could be over an hour presentation in and of itself. So basically, Freedom of Information Act covers two things, and it applies to public agencies, which you are. Also agencies like the town, housing authorities, and so on and so forth. And it's what has generally been known as sunshine laws. Other states have them. The federal government has it. And the basic principle is that it governs two things. The first is meetings, and the second is access to public records, which I'll talk about some detail. So start with the definition. And the FOI defines a meeting, and that's important because if it doesn't fall within this definition, you don't have to follow all the rules about FOIA. But any hearing, okay, so for example, if you had a hearing on a teacher termination or a hearing on a expulsion or something of that nature, that's pretty straightforward. Or other proceeding. Now that has been interpreted as being something more than a meeting, some kind of formal activity of some sort, so either a hearing or a proceeding. That's the first part. Or two, any convening or assembly of a quorum, okay, of the multi-member agency. So you could have a hearing or proceeding that just involves 3 members, right? There's not a quorum, but it constitutes a meeting. Or you can have an assembly of a quorum of your members. You meet, you talk. I'll talk a little bit more about this over the phone or email or so forth. That is considered an assembly of a quorum, and it should trigger all the requirements for a formal meeting, notice, minutes, open to the public, and all of that. And then the third item is any communication by or to a quorum of a multi-member public agency. So, once upon a time, people would get on a speakerphone or a conference call and talk. And if it's a quorum, then that's an illegal meeting. More recently, we've gotten into trouble. Folks have gotten into trouble through emails. Okay, somebody sends an email, somebody hits reply all, and now you've just had an illegal meeting. Okay, and it could also happen not so frequently, but it can happen even on a text chain. If there is a quorum on a text chain, then it is a meeting, or at least it meets the first part of the definition of a meeting. The second part is to discuss or act upon a matter over which the agency has control or supervision. So you happen to get together on the sideline, a quorum at a football game, and you're not talking about board business. Well, that wouldn't be an illegal meeting. If you got together for dinner or drinks or a holiday party, and you're not talking about board business, I know that's pretty unlikely, but that would not fall under the definition. So it wouldn't be a meeting. So, a hearing or proceeding, or an assembly or a communication among a quorum of you would constitute a meeting and needs to be noticed and so forth, as long as it's relating to something over which you have jurisdiction in business. Now, a meeting does not include, so for these things, you do not have to follow the rules, right? So the first one is a personnel search committee for an executive level employment candidate. Generally, a principal on up. Suppose there's an argument about assistant principals, particularly at the middle and high school level, but certainly a principal on up. And the way that normally would work is you would appoint yourself as the search committee. And once you've done that, you meet in private, you interview people in private, you deliberate in private. You don't have to do that stuff in public. Any chance meeting, social meeting, neither planned or intended to discuss business. That's, I gave you those examples. Number C, strategy with respect to collective bargaining. Once upon a time, you could go into executive session to do that. Not anymore. All you have to do, you don't have to do anything. You don't have to comply with the law. So if we wanted to strategize for teacher or any other bargaining unit negotiations, or I wanted to bring you up to speed, or Lori wanted to bring you up to speed, you could do that without following the rules. So you could just plan a separate meeting for that, or you could do it before a board meeting, but you don't have to follow the rules with respect to that. A caucus of a single political party, even if a quorum's present, all the R's, all the D's get together and talk about an issue, perfectly fine. You just can't have somebody who's not a member of the board there. You can't have the superintendent. You can't have the party chair there. You can't have the town manager. No, you can't have me. Nobody but your own party. And any communications limited just to notice of a meeting, who's available, Thursday, the 1st of February, people respond. That's okay. That's not a meeting. If it's just purely, communications about organization, that's fine. And all those things I've just talked to are sometimes referred to as non-meetings. Clearly an oxymoron, but if you hear the term, that's what we're talking about. The next item, I've already talked briefly about electronic meetings, but anything you can do through technology, the same rules will apply. Okay. All right, in terms of types of meetings, before I have a section I added today just dealing with these electronic meetings through electronic equipment. So this, what I'm talking about now, is purely in-person meetings. There are three kinds of meetings. There are regular meetings, special meetings, and emergency meetings. Going back to the regular meetings for a moment. At the beginning of the year, you're required, as I'm sure you do, you file a schedule of your regular meetings throughout the year. Those are, anything else other than those meetings are considered special meetings, okay? And importantly, for those, now you've already notified the public by posting your schedule at the beginning of the year, so you don't have to send out a notice again. But what you do have to do is agendas have to be made available to the public 24 hours in advance of that meeting. A little different rule when it comes to these types of meetings, which I'll get to in a moment. New business may be added to the agenda of a regular meeting only, not a special meeting. You need 2/3 vote to add it. You vote to add it, and then you would eventually vote on that particular issue. Your required votes have to be recorded within 48 hours of the meeting, and then minutes have to be posted within 7 days. A draft is fine until you finalize them, but those are the basic rules. Special meetings, again, are every other meeting. Notice has to be notice of the meeting, as well as the agenda. I mean, the notice serves essentially as the agenda, has to be posted 24 hours in advance, physically posted and on your website. And importantly, no business can be added to the agenda at a special meeting. Okay. Emergency meetings, as the name suggests, it truly has to be an emergency. The emergency is, I'm going on vacation and I want to get this, in beforehand, or it's not that, there's a vote coming up on something at the town and we want to get something. An emergency is, it truly has to be an emergency, and the Freedom of Information Commission, if it doesn't find it was an absolute true emergency, will find that it was improper. So it should be rarely invoked. You can call those meetings if it's a true emergency without the 24 hours, assuming that you don't have time for the 24-hour notice. Discussion is limited to the subject of the emergency. You can't pile on other topics, and minutes must be filed within 72 hours of that. Now, all of these meetings we've talked about have to be held and open to the public. But the Freedom of Information Act has recognized certain things that may take place in executive session. But because the general rule is that everything happened in the public, these exceptions are narrowly construed. The first one is that if you can, and by the way, you don't have to go into executive session. That's your choice, but you may go into executive session to discuss the appointment, employment, performance evaluation, health or dismissal of a public officer or employee. If you do that, however, the individual has to be told, and they have the right to insist that the meeting be in public. They don't have a right to come into executive session. You could hold the executive session without them, although often you will invite them in for at least part of it, but their only option is to insist that it be held in public. And a lot of times, we'll have the discussions ahead of time. Do you want this in open session? No, I don't. Okay. And we'll go from there. The second item B, strategy with respect to pending claims or pending litigations to which the agency or a member thereof is a party. So somebody's threatening to sue you. You're threatening to bring some kind of action against somebody. There is a pending lawsuit. You can talk about those items in executive session. Security issues, school security issues, clearly. Some of these other things are rarely would come into play, but D, discussion of the site or lease or for purchase of real estate. E, matters that would result in disclosure of certain public records that are protected. So where this is sometimes used is you want to talk to me about something, or maybe an attorney assigned by an insurance company about a pending case, but you want to talk to me. In theory, I can't just come in and have a discussion with you. But if I issue you an opinion, the opinion's protected by the attorney-client privilege, then we can talk about that issue. So if there's something you need to talk about, you want to do it in executive session, not in public, then that would be the mechanism for doing that. Now, some important rules about executive session. Only members of the board are allowed in, and people that you're inviting in, the statute says to give testimony or opinion. Okay, and their attendance is supposed to be limited to the time that's necessary. So pretty typical to have the superintendent come in to discuss one of these topics. Maybe you want the special ed director there, or Lori Lapine or Dave. You know, you can bring them in. You can't just let them in just because they want to be there and listen. You know, if again, I don't know why they would, but if the town manager or, you know, the party chair wanted to come in and listen to this topic, if they're not there to give an opinion or to testify, they really should not be allowed in there. Sometimes we're a little liberal with that. For example, where an employee wants to have their union rep with them, obviously we're going to allow that, that sort of thing. To go into executive session, 2/3 of you must vote to go into executive session on the issue. You have to start in public session. If your only item is an executive session, you can't start an executive session. You have to start in public session, make a motion to go into executive session. You got to have 2/3 vote to go in. And then importantly, you have to say why. And it's got to be one of those reasons. Discuss a personnel matter. If it's personnel, by the way, you have to indicate who it is. People are sometimes uncomfortable with that, but you do. If it's a single person, you know, superintendent, well, obviously you don't need to say the name, but if you were coming in to discuss, you know, custodian Floyd Dugas's performance or something of that nature, you'd have to say executive session, personnel matter, Floyd Dugas. Okay. And you have to say who you're inviting in. Okay. That's the another one of the requirements. If we could scroll down. Okay. I talked about point 3 here. You cannot take any action in executive session. You cannot take any votes in executive session. Now, I know there's a tendency to try to take a straw vote. You know, how does everybody feel about this? You know, how you I mean, it's okay to say, I think it stinks, but you can't say, well, I'm going to, you know, you can't go down the row, Ian, are you going to vote? How are you going to vote? Dean, how are you going to vote? That would be a vote, and that's improper. It's not improper if somebody says, well, I'm going to vote no. That's okay. It's not really a vote. That's just one person expressing their opinion, but you can't take any votes. Anything that happens in executive session, you know, the old analogy, anything that happens in Vegas stays in Vegas. It should stay in executive session. There are a myriad of reasons. You know, the legal one is if you disclose what happened in executive session, you have now turned it into an illegal meeting because you're not supposed to disclose what happens in the executive session. You potentially create a liability. I think it's up to $1,000 for the violation. But more importantly, it tends to create distrust among fellow board members when things are leaking from executive session. So for all those reasons, things really should not leave executive session. So now let me turn to the new rules regarding electronic meetings. And let me just say these are pretty new still. Like many statutes, they're not always perfect. They need to be interpreted, they need to be applied in sort of a best guess rational manner at some points. But there are some points that are pretty straightforward and clear. And importantly, all of this that I'm going to talk about now were part of a general, an executive order that the governor passed, a series of executive orders during the COVID pandemic. Those eventually expired, and those rules have now been incorporated, most, not all of them, into the Freedom of Information Act. And that's what I'm going to touch upon here. So it's broken down, you know, again, between regular meetings and special meetings. So first and most importantly, let me first talk about a regular meeting. So those are the meetings, you know, posted at the beginning of the year, as opposed to a special meeting such as this. So if, you know, you can have those meetings completely remote, or you can have them partly remote and partly in person, a so-called hybrid meeting. These rules apply to both. And the first thing, and this is where the rules change a little bit, is not less than 48 hours prior to the meeting. You must, number one, notify you guys, the board members, that there's going to be, it's going to be electronic. And you have to post a notice. That same notice that you're sending to the board members has to be posted at the central office, and the clerk's office, and on your website. And it must include instructions on how the public can access the meeting, what the link is. Okay. So that's 48 hours prior to the meeting, and you have to give the notice. And then the general rule about the 24 hours posting the agenda, that still applies, and you need to follow that. Next, some exceptions or specific rules that apply to a meeting which is completely remote, and no in-person component. And again, we're talking about regular meetings only at the moment. For, you know, a solely remote meeting like this, you must provide the public upon request with a physical location and equipment to attend the meeting. So this is obviously for folks who don't have access to a computer at home. You need to provide that if it's this type of a meeting, and they have to let you know 24 hours beforehand. So you're posting the notice 48 hours, and they've got to let you know 24 hours if they need a site where they could come in and have access to a computer. They've got to be provided with the same opportunity to provide comment and participate as if this were held in a public meeting. So if you have the public comment piece, you've got to allow the public comment piece. You don't have to do that if you don't already provide for it, but you've got to give them the same opportunity. These meetings, now again, we're talking only about a regular meeting held solely by electronic means. It must be recorded or transcribed and posted on the website within 7 days, and be posted there for not less than 45 days. Now, I'm just going to stop and pause here because I know there have been conversations about committees and so forth. The Freedom of Information Act only requires, the only meeting that you are required to record is a completely electronic meeting, a completely electronic regular meeting. It doesn't apply to part in person, you know, a hybrid meeting, part in person and part electronic. It doesn't apply to a special meeting. It doesn't apply to committee meetings. Okay, it only applies to a regular meeting held completely remotely. Now, if we can go down, talk about requirements for special meetings. So for a special meeting, for a typical special meeting, the notice and agenda has to be posted 24 hours in advance. That's still the rule. The only difference from what you do now is you have to state whether the meeting is solely virtual or part virtual, or a hybrid meeting, and then you have to include instructions on how to participate. Okay, those are the only rules with respect to electronic special meetings. Roll call vote. Any vote taken during a meeting, whether it's a regular meeting or a special meeting, that is either a hybrid meeting or completely electronic, you need to have a roll call vote unless it's unanimous. So if you get anything other than unanimous, a vote, you got to go back and take a roll call vote. The minutes must reflect which members attended in person and who attended electronically. Members or participants participating electronically, the statute said should use their best efforts to state their name each time before speaking. I know you guys have your name at the bottom of the thing, but still they ask you to make a good faith effort anytime you talk to identify yourself. If the meeting is interrupted due to equipment, internet failures, etc., it may be resumed the same evening as long as you provide at least 30 minutes, but not more than 2 hours from the point of interruption. And as long as there's still a quorum present. If for some reason you lost somebody, you no longer have a quorum, well, then you couldn't continue the meeting and you'd have to reschedule it at a later date. And the statute goes on to say, if practical, I don't know what that means, but I think it's probably a best effort approach. A notice should be posted on the website of the expected time you will resume. Sorry, folks, had electronic meeting problem. We'll be going back on at 8 o'clock, something to that effect. Okay. So that's the meetings. I'm gonna move on to public records. For the most part, you guys don't have to worry about this. Most FOIA requests will be directed. If you get one, you should direct it to the superintendent. And so you're not having to do the work and try to interpret the statutes. She'll know, or Joyce will know to pick up the phone and call me and ask a question if there's one. But just so you know, pretty much every piece of paper, every electronic record that the district has in its possession is a public document, and the public has a right to that record. Now, there are exceptions. You can scroll down, please, to page 6. I won't go through all of these, but just to give you some examples. For example, number 2, personal or medical files, the disclosure of which would constitute an invasion of privacy. You get a note from an employee, that they're having a medical procedure and they need a leave of absence. Well, that wouldn't be disclosable. Importantly, though, people sometimes think that means discipline because it's in a personnel file is not disclosable. That's not true. Discipline is disclosable. The only other thing that you would find in a personnel file that is not disclosable because there's an entirely different statute on it are evaluations of teachers and administrators below the rank of the superintendent. The superintendent's evaluation is available, but everybody else, certified staff, their evaluations are not subject to disclosure. Number 1, which I skipped over, by the way, preliminary drafts. We've got a draft of a contract we're working on. Well, that's not disclosable till it becomes a record. Number 4, we've got here records pertaining to strategy with respect to negotiations. Number 6, test questions. If you were to administer tests, those things aren't disclosable. I'm just going to jump down to some of the more relevant ones. Number 17, educational records, which are not disclosable under FERPA, the Family Education Rights and Privacy Act. So that's why student records are protected. So just some of the highlights of those. I won't get into the whole thing about what constitutes an invasion of privacy or not. That's really, that's really for the lawyers to look at and make a decision on. But we'll get FOI requests for the personnel file of employees from time to time, and we'll have to look at that. Just briefly, there are record retention rules. The state library publishes a whole set of rules in terms of how long you need to keep certain records and when you can dispose of them. And if that's ever an issue, it's available on the state website. Again, we're in the electronic age, and suffice it to say that the Freedom of Information Commission hasn't quite yet caught up with it, but under the electronic records, emails, emails, the way this is described, if it's the equivalent of a formal letter, dear Mr. Dugas, you need to keep it. If it's they refer to as a transitory communication, like, hey, Susan, can you give me a call tomorrow morning at 9 to discuss XYZ? Those sorts of things aren't required to be kept and recorded. Voicemails, a whole nother can of fish. Generally speaking, they can be deleted without any problem. And then the only thing I'll just mention briefly is if we're ever involved in litigation, the rules of the state and federal courts can hold it against you if you destroy a document or just get rid of a document after you've been notified of the litigation. So once that's happened, you really should preserve relevant records. Often, well, if that happens, and I can't remember ever doing this with Groton, but if that happens, we'll send a letter to you called the litigation hold letter, asking you to preserve certain records and documents. So it's another part of the FOIA piece. So with that, getting a little late, my voice is starting to fade. I'll turn it over to any questions you may have. Got this little cheat sheet at the end, but again, that applies to the regular in-person meetings.
Lloyd, I just wanted to mention tonight's meeting was a good example of it. This was originally posted to be in room 11 at the central office, but based on guidance from the federal, from the
Freedom of Information.
FOI administrator,
Yeah.
we have been posting these meetings as in-person / hybrid. And the FOI commission is current, I know this is subject to change, but is basically saying if we do it that way, we can cancel the in-person due to extenuating circumstances and just keep the hybrid. And that's actually how tonight's meeting played out.
Yep, and you shared that with me, and I was comfortable with that. This is a perfect example of not everything is addressed in the statute. Sometimes you just have to try to apply some common sense to it. For the most part, if you make a good faith effort to comply, first of all, if somebody doesn't file a complaint, then it's not an issue. But even if they've done and you've made a good faith effort to comply, even if they turn around and decide that was wrong, and trust me, just because you call one of the attorneys at FOI and they give you advice doesn't mean that FOIA is going to back them up on that. It's happened. Generally speaking, obviously this is what they do, all day long, and so they know it better than most of us. And generally their advice is helpful and good, but But I did agree with that, and that's a good example. We just have to do your best.
All right, and I see Ian has a question.
Yes, thank you. Yeah, so as you noted that the FOI Act is kind of still a work in progress, and I have to admit that I was one of the ones that was confused by the terminology between so you noted that special meetings and subcommittee, like the committee meetings that we have, like the subcommittees, policy, curriculum, all that, would not necessarily be included in the requirements for recording and
Recording.
publishing.
Correct. Generally speaking, committee meetings are subject to the same rules.
Mhm.
But the only meeting that by law must be recorded are fully remote regular meetings. So before that amendment and these electronic meetings, there was literally no requirement that you record any meetings.
Right.
Just keep
Well-
minutes and record of votes.
Right. So yeah, I mean, I honestly, yeah. So it seems like there's probably an opportunity there for improvement moving forward. If some legislator up there decides to take it on as a cause to make it more consistent across all types of meetings. Now that the technology exists and the bandwidth exists, I can say that it's an incredible resource to be able to go back and review meetings and take notes. Everything kind of happens at a good speed, at a good clip, and sometimes it's good to go back over and make sure you heard something the way that you heard it,
Right.
or not. So I will take note of that, and yeah, obviously, I think I was one of the persons who raised concerns about some of the meetings not being published, and so yeah, it seems like we have the law on the state level needs to be it could stand an amendment and revision to take out some of those inconsistencies.
Mhm.
So like tonight's meeting, not required by law to be published within 7 days.
You have to, the minutes have to be recorded within 7 days or published in 7 days. But you do not have to record and post on your website a recording of this meeting.
Because it's a special meeting.
Yes, sir.
Okay. But if it was a regular, so and like the subcommittee meetings, like the policy, curriculum, communications, and finance facilities, those
No.
qualify as regular meetings if they're regularly scheduled.
No.
Because of subcommittees.
Yeah, because they're subcommittees, they're not considered a regular meeting of the board.
So that's another area that might need to be specifically addressed in any revision of the law.
Possibly, yes.
And as far as executive sessions go, looking down the reasons for executive session, it says appointment, employment, performance evaluation, health or dismissal, public officer or employee. So the is it acceptable to have an executive session to interview candidates, or is that just for evaluation of candidates that might be hired?
You could, I suppose that would fall under the employment, but if you did talk to them in executive session, you would have to list their name on the agenda. So, interviewing personnel, interview of Floyd Dugas. And some folks may not want their name, out there, particularly if they currently have a job. But yeah, you could do that in executive session.
Okay. All right. Thank you.
You're welcome.
Any other questions for Floyd?
Nobody's nodded off yet. That's a good sign.
Well, it's a lot, and actually, I learned a couple things tonight, going through some of the new, because I think we've been a little bit loose on, we sort of know when remote members are speaking, but I guess we can try to be a little more careful about announcing, who we are before we speak. I think it's helpful that the name is on the Zoom, but we'll have to tighten up on things like that.
Yep.
All right. Anyone else have anything to add? All right. If not, I want to thank you, Floyd.
My pleasure, anytime.
You've given us a lot to think about, and in addition to what we discussed at the beginning of the meeting, we've got a little homework to do.
Absolutely.
So,
All right. Well,
all right.
good night, everyone.
All right. Thank you.
Yep.
Thank you very much.
Does anyone want to make a motion to adjourn?
Motion
Can
to
I make a
adjourn.
motion to adjourn? Second.
Motion to adjourn.
So Andrea first, Adrian second. Any opposition? Thank you. Have a good night.
Yep, thank you.
Good night, everyone.
Good night, everybody.
Good night.